Welcome to this explainer from American Law Cafe, where we're breaking down the powers that shape our entire legal world.
This very question, it sparked one of the biggest power struggles in all of U.S. history. And back in the nation's early days, the answer was, well, it was anything but certain.
All right, so here's our game plan. We're going to look at how the Supreme Court became the ultimate legal referee, starting with a last-minute power play. Then we'll see how the Constitution became the supreme law of the land, check out the toolkit justices use to make decisions, and finally, look at the power they have and its limits.
Okay, first up, let's define the court's superpower. And get this, it's a power that isn't even written down in the Constitution, but it's become a cornerstone of American government.
And that power is called judicial review. Think of it like this. It's the power of the courts to look at a law from Congress, or maybe an action from the president, and ask, hey, does this break the rules of the Constitution? It's literally like a referee blowing the whistle on an illegal play. If the law is unconstitutional, it gets tossed out. It can't be enforced. Simple as that.
So, you might be wondering, how did the court get this incredible power? Well, it wasn't just handed to them. No. It was seized in this dramatic political showdown that, honestly, it reads like a thriller. Okay, set the scene. It's the chaotic election of 1800. President John Adams and his party, they just lost, big time. So, in a desperate, last-ditch effort, they create a whole bunch of new judge positions. And in the final hours of the administration, they're literally signing commissions to pack the courts with their allies. But it's a mad dash, and in the chaos, not all the paperwork gets delivered, including the commission for a guy named William Marbury. The very next day, the new president, Thomas Jefferson, takes over. His team finds the undelivered papers and just refuses to hand them over. So what does Marbury do? He sues. And here is where the story gets really good. I mean, this is an incredible twist. Marbury takes his case straight to the Supreme Court. And who is the new Chief Justice? None other than John Marshall, the very same guy who, as the last Secretary of State, was supposed to deliver Marbury's paperwork in the first place. I mean, you can't make this stuff up. This sets the stage for an absolute classic showdown between Marshall and the new president, his political rival, Thomas Jefferson.
So Marshall's ruling, it was just a masterclass in legal strategy. He broke it down into 3 simple questions. First, does Marbury have a right to the job? Marshall says, yep, he sure does. It was signed and sealed. Second, does the law actually provide a solution for this? Again, Marshall says, yes, it does. But then came the third question, and this was the brilliant trap. Can the Supreme Court actually issue that solution? And Marshall's answer was a huge, history-making no.
And here's the genius of it. Marshall pointed out that the law passed by Congress, the Judiciary Act of 1789, which gave the court the power to issue these orders, was actually in direct conflict with the Constitution itself. See, Article 3 of the Constitution puts strict limits on the kinds of cases the Supreme Court can hear right off the bat. And this just wasn't one of them. So you have a law from Congress on one side and the Constitution on the other. They're at odds.
And in his ruling, Marshall writes this now famous line. It is emphatically the province and duty of the judicial department to say what the law is. So think about what he did. By giving up a tiny bit of power in this one specific case, he avoided a direct fight with the president that he probably would have lost. But in doing so, he grabbed a much, much bigger prize, the power for the court to be the final interpreter of the Constitution. And just like that, judicial review was born.
Okay, so the court has established judicial review over federal laws. But the next big fight was about who exactly this applied to. I mean, could the U.S. Supreme Court really tell a state's highest court what to do?
This whole question just exploded in a case called Martin v. Hunter's Lessee. You can see the 2 sides here. Virginia's highest court basically said, hey, we're a separate sovereign government. The U.S. Supreme Court has no authority over our rulings. But the Supreme Court fired back, saying, no, the Constitution is the supreme law of the land, and that applies to every single judge, state or federal. In this really powerful opinion, Justice Joseph Story argued that if you don't have a final referee, it's just total chaos. Federal law would mean 50 different things in 50 different states. The Constitution wouldn't mean one thing, it would mean dozens. To make sure the law is uniform across the country, the Supreme Court had to have the final word on issues of federal law. All right, so we know the court has this immense power. But how how exactly do the justices decide what the Constitution actually means? It's not nearly as simple as just, reading the words on the page. Well, justices have this common toolkit they use to interpret the Constitution. There's textualism. What do the words literally say? Originalism. What did they mean back when they were written? They look at history and tradition, the overall structure of the Constitution, and of course, precedent. What have past courts decided? And sometimes they even bring in moral reasoning, thinking about justice and evolving values. And what's fascinating is that even within a single one of these tools, there can be huge debates. Let's take originalism, for example. Some justices try to figure out the framers' original intent, like what was James Madison trying to accomplish here? But others focus on the original public meaning. What would a regular person back in the 1780s have understood these words to mean? And believe me, those two approaches can lead to very, very different answers. Of course, a power this big doesn't go unchecked. That's not how the system works. There are built-in limits, both from inside the judiciary and from the other branches of government. First off, state courts have this really clever escape hatch. It comes from a case called Michigan versus Long. It's a doctrine that basically lets a state court protect its decision from the Supreme Court. All they have to do is make a plain statement that their ruling is based only on state law. If it doesn't touch on federal law, the U.S. Supreme Court can't touch it. Then there's this really powerful internal check, this constant debate between judicial restraint and judicial activism. Now, this isn't really about being liberal or conservative. It's about a judge's philosophy on the court's proper role. Should judges basically defer to the elected branches whenever they can? Or should they be willing to step in and strike down laws to protect people's rights, even if it's unpopular? Justice Oliver Wendell Holmes Jr. had this very extreme view of judicial restraint. He famously said, "If the people want to take this country to hell, it's my job to go with them." He was basically arguing that a judge's job is just to uphold the law that the people's representatives pass, whether the judge personally thinks it's a good law or a really, really bad one. And family, you've got the external checks from the other branches. The biggest one is a constitutional amendment, but that's incredibly rare and hard to do. What's more common is the appointments process. The president appoints justices and the Senate confirms them, which shapes the court for decades. And yeah, impeachment is technically on the table, but for disagreeing with a ruling, it's pretty much a non-starter. So we've traced the court's incredible journey from what was once called the weakest branch to the ultimate legal referee. And that leaves us with this really critical question for our own time. Is the court still just a neutral umpire, applying the rules as they're written? Or has it become an active participant? If you found this breakdown helpful, do us a favor and hit like, and be sure to subscribe for more explainers like this one. And for more fantastic conversations about the legal world, you've got to check out American Law Cafe. You can find it anywhere you get your podcasts.